Hello, everybody, and thank you for joining me for a talk on qualified one-way cost shifting in Scotland. As I'm sure all of you are aware, Part 2 of the Civil Litigation Expenses and Group Proceedings Scotland Act 2018 gave the court power to make regulations to introduce QOCS, as I'll call it from now on, which have been in existence in England for quite a while now. The key point, of course, is that in personal injury claims, the traditional rule that expenses follow success no longer applies to defenders, although it does for pursuers, subject to the very important qualification that the pursuer, quote, conducts the proceedings in an appropriate manner, unquote. And what I'm going to be doing today is looking at exactly what this means. As I mentioned earlier, England and Wales have had QOCS for considerably longer than in Scotland, and the case law is still pretty limited north of the border. So it does make sense, at least, to have a look at the experience south of the border. But in doing so, it's very important to remember that the rules in Scotland are significantly different from the rules in England. The rules in England are set out in the Civil Procedure Rules in Chapter 44. And Rule 44.16 provides that orders for costs made against the claimant may be enforced to the full extent of such orders with the permission of the court where the claimant is found on the balance of probabilities to be fundamentally dishonest. And that's the unitary test in England, is one of fundamental dishonesty. And the first thing that you'll notice is that the words fundamentally dishonest don't appear anywhere in the Scottish rules. Another issue which has arisen in England and is likely to arise at some point in Scotland is the question of counterclaims and who gets what protection. So if A sues B in a head-on road traffic accident and then B sues A in respective injuries in the same accident, who's the pursuer, who's the defender, who gets QOCS protection. And in England, there are two county court decisions which unfortunately conflict. The first is the case of Ketchen against McEwen, and the second is a case of Waring against MacDonald.